Welcome, everyone. My name is Ira Belkin. I'm a senior research scholar at the U.S. Asian Law Institute, and we have a fantastic program this morning, which we'll get to in just a minute. We have Professor Grace Moe from London, who's going to be talking about her new book, Constructing Guilt in China. Before we get to that, though, I just want to make one announcement. As you know, our program, we have a speaker program pretty much every Wednesday morning, usually at 9 a.m., unless we have a different time because of time differences of where the speaker is, but generally at 9 a.m. And next week, we're going to have a program on the future of overseas NGOs in China. This will be a deep dive discussion about the foreign NGO law, which has now been in place for about 5 years. And we have a fantastic group of experts, including our own Catherine Wilhelm, Executive Director of the U.S. Asian Law Institute, Mark Seidel, who's also an expert in this area, professor from the University of Wisconsin Law School, and Jessica Batke, who's editor of the China NGO Project at China File at the Asia Society, who's been focusing on the foreign NGO law and how foreign NGOs are complying and dealing with the law in China. So next week's program should be also fantastic. But I don't want to take up too much time. I just want to say I've been reading Grace Moe's book, and I've just found it fascinating. She has had access to the day-to-day workings of the Chinese criminal justice system, having been, and she'll talk about how she was embedded in a prosecutor's office for a period of time and had access to case files. And she's combined her empirical research with her, based on her observations and interviews, with a encyclopedic knowledge of criminology and social science, putting what she learned in China into a broader context. And so I'm very much looking forward to her talk this morning. She's going to start by giving us a presentation with a set of PowerPoint slides, and then we'll open up the discussion. So as we usually do, we'll ask you to put your questions in the question box, and we'll try to get to as many questions as we can during the discussion period. So Grace, with that introduction, I'm going to turn it over to you.
Okay, thank you very much for inviting me, Ira and Catherine. It's my great honor and privilege to be here and to talk about my book. So I'm going to share my slides. I will start with the reason why I choose this topic as big as this one. So when I was a teenager watching a show, the trial for the first time in a court, I was very curious about why there was no witnesses, because when I was watching the TV, for example, this trial, lots of court dramas is all about cross-examination. So I was excited about seeing how the witnesses was actually being cross-examined. But in the Chinese context, this was absent. So all I could see was defendant being standing in the dock. And then you got prosecutor and the defense lawyer. Of course, you got judges, and then prosecutor just read out the case the notes, and then defense lawyers reading out this his pre-prepared all kinds of statements. So that's a kind of a trial in China. Witnesses really come to the court to testify, and there are lots of surveys really show that less than 5% of witnesses actually come to the court. So that really make me interested about what actually happened in the background. So why witnesses do not come to the court? This has been one of the biggest mystery in the Chinese criminal justice. And over the last, I think, 20 years, lots of research has been focused on studying why witnesses do not come to the court. So they focused on the case, witnesses protection, why a witness is reluctant to come to the court, and also why the judges prefer to use written documents rather than oral testimony. So those are the kind of research has been conducted. But for me, I was quite intrigued by the fact that if they really do not want to use a live testimony and rely on a case dossier, how the case dossier was formed, is it really reliable? Because at the end of the day, it is about the thing that actually the court rely on, that the person's guilt or innocent is finally determined. So that's what my research interest was all about. And so my interest that drives me to do that research, and during the whole course of the field work, I found that the case dossier indeed is one of the most important instruments in the Chinese criminal justice system. So case dossier is almost the same as a critically important by every stage of the criminal process. I remember that when I was doing a participant observation in the prosecutor's office, and on one day, one of the prosecutor has found that one of the case dossier was missing, and this caused absolute chaos in the office. Everybody was looking for this case dossier, and it was regarded as a major incident. So the case dossiers are extremely important to every legal actors involved in the criminal justice system. But strangely, there hasn't been much research focused on how the case dossiers has been formed. How is it constructed? And basically, the case dossier is about evidence, how the evidence was acquired, how is it being constructed, and is it really safe? So that drives me to look at this project about construction of guilt in China. So this is the first slide that is about how the case was constructed. When the case was started with the police investigation, how the police identify the truth. So for the police, the truth is actually determined usually by the first source of information that reached to the police officer. For example, the police officer could reach out a person who reported the crime, and then during the course of the investigation, he will receive other sorts of information, and then he would kind of putting all the information together and identify a kind of official version of truth, that is the truth that's being generally generated during his investigation, and then he will put it down as a kind of a truth. And all the kinds of pieces of information would then be adjusted to align up with this information. And manifested in the case dossier is the fact that all the case dossiers would appear to be very consistent. So there rarely are any obvious contradictions with each other. And this is one of the two statements in one of the case dossier which I have managed to identify. So if you look at this slide, that the top one is a victim statement, and the lower one is the interrogation record. And for those records, only slightly some of the words are modified, but the key words and key statements are very much similar. So how the official version of the truth has been created? It is about the police officer would find the investigation direction at the beginning of the investigation, and then later evidence which come into being that to some extent is a reflection what has been known. So in that way, all the evidence is kind of appear to be consistent and coherent in that way. So on one occasion, I asked the police officer why the language looks so similar. And the police officer said they have to determine the investigation direction in the beginning, and then the initial account reported by the victim and the informants later is the cornerstone of the investigation. So that later evidence would reflect on the victim's account. So that's how the information was being lined up. But this is actually quite controversial, because if you think about it, sometimes the victims and witnesses, they come from very different social background, and their education level is different. And so it appears to be very strange if they use a similar type of language, similar type of words, and the keywords they use, even though the different people might describe the same thing with different words, but the keywords always remain to be the same. So this kind of practice is quite familiar to the prosecutors as well as the police officer. There are sometimes occasionally that the prosecutor would find out this very artificially modified statements. So on one occasion, the prosecutor has explained to me that the prosecutor have to warn one of the police officer that the details, which if they put exactly in the same details, that might cause some kind of a suspicious. So in order to make the appearance of the case dossier looks genuine, they sometimes have to create some kind of reasonable discrepancy, so the evidence would look more convincing. And if as I said, if you try to match everything in a case dossier, the effect may be contrary. So the question is why the police officer wanted to do that. The reason for this is because according to Criminal Procedure Law 2018, actually also appeared in earlier versions of the Criminal Procedure Law. So for example, in Criminal Procedure Law 1996 and also Criminal Procedure Law 2012, there is always an article. So in 2018, the articles that Article 200. So that article is the Corroboration Rule, which means that the court would only convict a case if all the evidence have been referred to each other and leading to the single outcome that which is the guilt of the defendant beyond reasonable doubt. So that is how the court can convict a person. And this article is important because it sets the guideline for the court for the adjudication, and also set the guideline for the police and the prosecutor. When prosecutor reviews the case dossiers, examine the case dossiers, he or she is about looking at all the evidence and check whether all the evidence is consistent. If there's some kind of obvious contradiction, then the evidence may may become a problem. So they have to resolve that problem. And if you think about it, like in adversarial system, if there is contradictory evidence, it is about cross-examination to find out which evidence can be accepted. But in China, because all the evidence is in writing, so it has become a big task for all the legal actors to make sure that the evidence do not appear to be obviously contradictory. This is one of the examples So on this example, on this slide, you could see that one of the defense lawyer who talked to his client, and his client then referred that back to the defense lawyer saying he actually confessed, but the police officer refused to put down what he said because the police officer believed what he confessed was not conform to the direction which the police desires. So that really shows the evidence. The police case is constructed, and this constructed truth in China is labeled as a official version of truth. So it's a little bit ironic because in China that it's a country that enshrines Marx-Leninism, and according to Marx-Leninism, that truth is the absolute truth. So it is all about the truth that reflects the real world, reflects what the facts, what factually happened. But as my research. So when I did my research, I found it is not the case. It is all about how people perceive the truth, how they contemplated the facts, and then individually they try to edit the evidence, they try to adjust the evidence to make sure that the truth looks to be genuine, looks to be convincing, in accordance with the law, and appears to be lawful. So this is one of the example. On this example, the police officer has interviewed one of the suspects, and the suspects amazingly was able to memorize all the serial numbers of the clothes he has stolen. So anyone who who probably not interested in that industry wouldn't, or in that shop wouldn't be wish to memorize such a boring long serial number. So and when the police asked, did you confess the truth? And then the suspect said yes. So this is really an example, shows that the confession is a collaboration between the police and the suspects. Otherwise, there's no other ways to interpret that anyone would want to memorize anything like this. And similar example have been found repeatedly during the course of my research. So for example, sometimes the police would ask the suspect, can you remember the credit cards you stolen? And then without any mistake, the suspect was able to list all the 6-digit credit card number, and also the numbers of the victim's telephone books, etc. So all kinds of evidence shows that there is a collaboration between the police and the suspect during the course of the interrogation. But those things, those details are not showing on the official police files. So that's the police investigation. And once the police had finished the investigation, then the case would move on to the next stage, that is the prosecution review stage. So in China, that prosecution review happens after the investigation completed. And for the prosecution review, this is actually quite important criminal justice stage, because they really need to show, to identify whether the case is strong enough to be prosecuted and to move to the next stage. And in China, that probably many of you have heard about it, that the conviction rate is very high. So over 99.9% of the cases are convicted. And the reason for that is because the prosecutors are under the appraisal system. That means the prosecutor would would not wish to have any of his cases being acquitted. If a prosecutor got acquittal, that means his career is significantly in trouble. So he would have a difficulty to get promotion, or his salary might be deducted, and he might even affect the reputation of the general procuratorate, which he worked within. So under that kind of pressure, the prosecutor really try to make sure that they try to make sure the case that has been prosecuted is very strong. But this is actually quite difficult, because the case which is investigated by the police is not always strong. There are lots of weak cases, and the prosecutor, they have to maintain a good relationship with the police in most instances, so that he can give them the instruction, and the police officer can then go back to do some of the reinvestigation to strengthen the case. And for the prosecutor, they are not really impartial as some of the inquisitorial countries. So for example, in countries like France, Germany, or other inquisitorial countries, the prosecutor is like a standing judge. They have the duty of being objective. So they are not just only to look at the case, to gather and look at the evidence, which might lead to the conviction of the defendant, but they should also pay attention to exculpatory evidence. And in China, that the prosecutor is, although they have the role to be impartial, and they have they're supposed to be safeguards of the criminal justice, to make sure that everyone do the correct enforcement of the law, do their job properly. But in China, the prosecutor, in fact, is not a partial officer. And during my field work, I interviewed lots of them, and many of them were quite frank and say that because of the pressure they were under, it's actually impossible, and their role is basically to fight against the crime. In order to fight against the crime, how can they do with the weak cases? The solution is to pass the cases if the defendant plead guilty. So similar to the American system, that guilty plea plays a big role in the criminal justice system. In China, guilty plea is also important. So if the defendant pleads guilty, that means the case will be quickly disposed of through the guilty plea procedure. And now in China, there is a new system, which means which is called 认罪认罚, that is plea leniency. In other words, if the defendant plead guilty, then the procedure will be streamlined. Excuse me, and then the case would not be carefully scrutinized by the court. So that's how the vast majority of the cases has been being processed. And in this slide, you can say this is one of the prosecutorial interrogation. So in China, there is a procedure in a prosecution review stage. That is, all the prosecutors are supposed to interview the suspects or interrogate suspects. And what's the main function for this prosecutorial interrogation is to procure guilty pleas. And if the suspects refuse to plead guilty, then the prosecutor would put lots of pressure on the suspect to make sure that he pleads guilty. And if even though a lot of pressure is still put on a suspect to plead guilty, and the suspect still refuse to plead guilty, then the prosecutor will proceed with the charge, and then threat with a sentence, higher sentence, etc. So the prosecutor actually is not a neutral officer. He's very much teamed up with the police officer to make sure that the cases can be safely delivered to the next stage. So that's the prosecution review stage. And finally, when the case comes to the court will look at the cases. But during the course of in the criminal procedure, that defense lawyer, they have been not being recognized as part of the criminal justice system. They are outsiders. So in China, there is a notorious Article 306 of the criminal law, which basically said the defense lawyers, if they committed fraud, evidence perjury, then they would be investigated and being sentenced to like 3-year imprisonment. So because of this article and also other obstacles, defense lawyers rarely be able to independently verify the prosecution evidence. And sometimes if the defense lawyers started to verify and contact the witnesses to verify the evidence, then the defense lawyers would be threatened by the prosecutor or the police for this perjury. So that made it very hard for them to independently construct the defense case. And also they have difficulties in accessing the case dossier to meet their clients in the detention center. These are all very difficult. Defense lawyers have all sorts of difficulties in construct defense evidence. So that puts them in a very difficult situation when the case goes to the court. In the court, the court does not treat the prosecutor and defendant equally. Generally, there is a close relationship between the prosecution and the judges. They are very close. Lots of them are close friends. So for example, when I was doing my field work in the prosecutor's office, sometimes the prosecutor would say that this judge friend came to the birthday party, something like that. And when there is a problem in the case, the prosecutor can just phone the judge to explain the situation. And then there is a negotiation between the judges and the judge and the prosecutor. So there is a clearly close relationship, and everything how the case is going to be adjudicated is occasionally being revealed to the prosecutor. So for the prosecutor, the progress of the case is almost like transparent, but this is not the case for the defense lawyer. Defense lawyers usually not knowing all the details. And when the case was tried, their evidence, if they produced the new evidence, would be subject to severe scrutiny. So lots of defense lawyers were actually being discriminated by the court, even though their evidence may appear to be strong and convincing, but the court may not accept their evidence if their evidence turned out to be contradictory to the prosecution evidence. So the court, as I said, it's really, it is about reading out the statements and not cross-examine the witnesses. So for the prosecutor, everything, how the case is going to be adjudicated, the outcome of the case was usually informed to them in advance. So everything is quite transparent to them, but it's not the case for the defendant or the defense lawyers. So this is in this interview transcript, you could say this is one of the example that one of the defense lawyers told me that the judge actually did not accept the evidence he has produced at the court. So and it's really hard for the defense lawyer to convince the judge. If the defense lawyer wanted to convince the judge, they have to put more effort and to really put a very convincing statement, and maybe use all kinds of techniques to make sure that the prosecution evidence is flawed and that their evidence is much stronger. So it's much more difficult. I would wrap up with my presentation. So what is the big message of my my book? It is, for me, the message is about the integrity of the criminal justice system. I think that integrity is quite important for any criminal justice system to be function without correctly, to also to make sure that it's uphold its core values. But in China, that the criminal justice system lacks integrity, and this lack of integrity can be demonstrated in the police case construction, and also demonstrated how the prosecutor treats the police case, and how the prosecutor examines the case and treats the defendant. Of course, it is also about the absence of witnesses and the court's attitude towards different legal actors, especially how they perceive the defense evidence, which is discriminatory. And for me, that the Chinese criminal justice system looks like half of the adversarial system. So although Chinese criminal justice system is usually considered as a hybrid system, so for example, some of the procedure setup is very similar to inquisitorial system. There are lots of principles and lots of the procedures similar to the continental inquisitorial setup, but for me, the case construction is very, very similar to the adversarial system. It's only half of the story. It is the police constructs the case, then puts the evidence to the court. But the defense side has been suppressed, so it is not the full truth as you could sometimes say. It's only half of the truth, and the truth is the official recognized truth. And then the reason why the criminal justice system is designed in this way, it is about how they perceive the criminal justice system. In China, that criminal justice system is a mechanism of control. So anyone who has been implicated in the criminal justice system would be very difficult to get out of the system. So there, either through the decision not to prosecute or through the acquittal, those two channels to get someone out of the system is extremely difficult. Now, in recent years, that the prosecutor has been given more discretion, so that the rate of not to prosecute the cases discontinued has been increased, but still the acquittal rate is extremely low. And the prosecutor who decide not to prosecute the evidence, the number is still very small. So that comes to my conclusion that his criminal justice system in China is structurally weak, and there's no surprise there are miscarriages of justice and the wrongful convictions. So here I shall stop my presentation. Thank you.
Grace, that was terrific. I think in a very short time, you've managed to kind of flesh out some of the problems with the Chinese criminal justice system. A lot of the criticisms that have been leveled over the years, which focus primarily on the text and occasionally cases that illustrate those problems. Most observers just haven't had the kind of access that you've had. And I think you've also managed to explain how some of these deficiencies really manifest But I want to start off by asking a couple of just clarifying questions. You talk about the case dossier, and I wonder if you could just spend a couple of minutes explaining exactly what the case dossier is, who puts it together, who decides what goes in and what doesn't go in, and how that dossier goes from the police to the prosecutor and the court.
Yeah, thank you very much, Ira. Yes, a case dossier is truly the most important asset or instrument for the criminal justice system. When you refer case dossier, there are actually different types of case dossier. So my research focused on investigative case dossier, that is 侦查卷宗, the investigative dossier. For every criminal justice institution, they would produce their own case dossier, including the defense lawyer. So, for example, the court would have the court dossier to document all the procedure and decision making. They would have their dossier, different categories of dossier. So, for example, for the court, they would have the case dossier, and also internal case dossier that is not reviewed to the public or reviewed to outsiders. But the general case dossier occasionally can be open to other people. For my research, is about investigative dossier, that is the kind of evidence that being collected and compiled by the police. So it is a police officer, investigating officer, who compiled the case dossier. So the case dossier has a strict way to compile. So for example, the first it always starts with the defendant's basic background, his education, family, his race, this personal data, and then followed by how the case was reported, who arrested the defendant, etc. So there is a set order what evidence should be put into the case dossier and how the case dossier should be assembled. There are strict rules as to the assembling of the case dossier, and then this case dossier. So for the police, there are generally two different types of the case dossier. The first one is the evidential case dossier, that is it's about all the evidence. Then you have the procedural case dossier, that is it's about compulsory measures that police have been taken to control the defendant. So, for example, his detention procedure, his how he was arrested, and who whether there is a bail, that kind of information. So it's about so for the evidence. So the case dossier for the police is a evidential case dossier and procedural dossier, and that two type of the case dossier would be transferred to the prosecution, and then from there they would go to the court.
Great. And just a follow-up question, and this reflects some of the questions in the that audience members have asked. Is there also a kind of a secret file where the police keep some of the evidence that they don't necessarily disclose to the prosecutors?
Yes, I think so. There are, for each institution, there is also always a internal case dossier known as 内卷. So that is a information not revealed to generally outsiders. Is only to be kept to the small number of key officers. So, for example, in the police, for the police, there is internal case dossier is about informats, police informers, that kind of information, or other type of information which may be inconvenient to tell the other people, such as, for example, there might be some procedure problems. Yeah, they do not wish to tell Yeah.
And you mentioned before, and you go through this in the book quite in more detail about, the police may discover some exculpatory evidence. They're not really looking for it. Is it possible, or do they always put the exculpatory evidence in the evidence file that goes to the prosecutor in the court? Or is that sometimes, if they decide it's not credible or it doesn't detracts from the corroborating, the requirements of having corroboration, do they just not disclose that?
Yes, so for the police officer, they're supposed to put all the inculpatory and exculpatory evidence in the evidential case dossier, but the kind of exculpatory evidence has been contained in the case dossier is usually about the person's voluntary surrender, or he has a performance, he has, for example, informed and detected other crimes, so he could claim some credits. So that kind of mitigating factors, but it is not directly central to his guilt. So for example, if he put a alibi or self-defense, and self-defense, for example, can be put in the case dossier, but alibis, for example, I have never seen any of the case dossier contains that kind of damaging evidence to the prosecution and evidence prosecution case. So all this kind of case dossier are compiled in that case dossier from the prosecution then to the court. So it's one set of a case dossier.
Okay, great. I'm going to turn to some of the questions in the queue. We have quite a few questions, but before we get to those, Grace, I wanted to ask you, the title of your book is Constructing Guilt. And it made me think my experience as a prosecutor in the United States, and I think investigators all over have to construct a case. They have to put a case together. They start with a theory of the case, and then they go out and gather evidence. And how do you compare the Chinese system with whether it's the American system or other systems? The investigators still have to put together a case. How is it different when we get to the US system, for example, where witnesses do have to come to court? They are subject to cross-examination. The witnesses may include the prosecutors. I'm sorry, may include the investigators. Anyway, let me stop there and just let you answer.
Yeah, there are, of course, similarities in the case construction process. And I think case construction is everywhere. So for the prosecution, they have to construct the prosecution case. For the defense lawyers, they have to construct defense case. It is not about the construction of case. It is about whether the prosecution case can be challenged. So for example, in America or in other jurisdiction, the court is a forum, is that stage where the prosecution case can be challenged. So the defense lawyers can and challenge the prosecution, and then to prove that, to show that the prosecution case is not beyond a reasonable doubt, then on that basis, the case can be acquitted. But in China, this kind of mechanism is lacking. So there's no such forum in China that the prosecution case can be seriously challenged. For instance, for the defense lawyer, if they wanted to construct the defense case, they would came across hurdles at the very beginning. So if they started to contact the prosecution witness to verify their evidence, they would be in trouble. Article 306 of criminal law. And also they even have access to, to the case dossier to know what the prosecution case is about. And sometimes they have difficult to access their clients and the detention center, whether that's monitored or not, we don't know. So they come across, they encounter a great deal of difficulties in constructing the defense case. And for me, that's the difference between Chinese criminal justice system and other criminal justice system, is that Chinese criminal justice system is a official recognition process. So if you look at it, the police is representing the state. They detect a crime, they investigate a crime, and then they formulate a fact, and that fact is officially recognized. And then that move on to the next stage, which the prosecution is to verify the evidence, to examine the case dossier and say whether the case is, is it worth moving to the next stage. So again, that is about kind of a confirmation, to this official version. And if that is done, then the court is finally about certification of this official version. So that is a one straight line. In this process, it's really difficult to challenge this officially recognized truth. So that's the difference between China and other jurisdictions, in my opinion.
So it sounds like the purpose of the process is to just refine the prosecution version of the case throughout the system. And there's no place in the system to test the validity of the investigation and the evidence, which is really what the criminal procedure really should be about. I have many more questions, but I've been monopolizing the questioning, and I want to turn it over to some of our audience members. So maybe if we could have Professor Alvarez start, and then we'll go to Professor Cohen after Professor Alvarez.
Sure. Thanks for the opportunity. I very much appreciate the talk. It was very candid, and that's, I guess, part of my question. I was surprised somewhat how candid prosecutors were to your questioning, because I assume, and maybe I'm wrong about this, that one of the characteristics of China is its lack of transparency, and that you were able to pierce that is a bit of a surprise. And perhaps you address this in your book, but what do you think the consequences of revealing this will be in China? Will it cause reform on the one hand, or will it cause prosecutors to be reprimanded from talking to people like you, or some other way of imposing silence again? I'm just curious, how do you see your work on the effects of criminal justice reform in China?
Thank you very much for your question and your concern about my research and myself. What you have said is actually quite true. For a long time, I was quite hesitant whether I should really publish my book. But I think it is worth publishing so that people know how the criminal justice system is actually works, especially the inner working system has not been really researched before. So it is a bit of problem, and for me, it would be more difficult for me to access a field site in the future, which I have a kind of a struggle with. Even without publishing a book, that under the current regime, that it is doing field work is more difficult for external researchers. I was extremely lucky when I had access in a prosecutor's office when I was doing my PhD. So at the time that there was a relaxation in Chinese society, and the way that the the criminal justice institution works was much more liberal than today. Today is very how should I say? Today, the criminal justice system is much more hostile to external researchers. Maybe I put it too much. Yeah, it is. There is definitely a concern. And so in my book, I have described how I access the field site. So I basically work with the prosecutors every day. They see me as one of them, and then so I know what they are doing, and so there is a kind of a trust formulated between me and the other prosecutors who I worked with. Of course, I have to make sure their identities are anonymized to protect their personal identity, etc. But yes, I don't think the book will be welcomed by China, but nevertheless, in the Chinese academia, there is a consensus that a miscarriage of justice needs to be addressed, and there has been reforms taking place to address the issue. So, for example, the prosecutors are now have this. Are given more discretionary power to discontinue the prosecution case if the case is not strong enough. And there is also exclusionary rule in place to exclude illegally obtained evidence. So there are some reform taking place because the system actually aware that there are some fundamental flaws, and that flaw will directly lead to wrongful convictions. And the wrongful convictions, once they are published, they are being known to society, will be damaging to the reputation of the criminal justice system and the public trust. So there are a range of a series of consequences as well. So I just criticize the criminal justice from this how the case is constructed. For me, that is the root of the problem. But unfortunately, that problem has not been addressed in China so far, even though there are a number of reforms being taking place.
Great. It's a really comprehensive answer. Perhaps we could get Professor Cohen's mic turned on. And while we're waiting for Professor Cohen, I just want to follow up and Grace and ask you whether you think your book or any portions of it might be published in Chinese in China. And, you know, in the Chinese language academic press, there's a great deal of criticism of the Chinese criminal justice system. I mean, I haven't read anything as comprehensive as your book, but certainly there's a lot of criticism of various aspects. So I think we do have a sense from reading the English language publications that maybe the system is not as open to criticism as it actually is within China. So do you think there's a chance that either the whole book or portions of your book might get published in China, or that you could, yeah.
I probably wouldn't encourage, because, you know, as you said, they are not open to criticism. And actually, some of the academics who have picked up some of the issues, but, you know, they have to write in a very diplomatic way so that this kind of issues can be heard. In order to publish a book that you know, very, very critical, it's gonna be very difficult to be accepted, and to the publisher as well. I don't think any publisher would be willing to run that risk.
Okay, Jerry, I see your name on the list. Is your mic working?
I don't know. Can you hear me?
Loud and clear. Please go ahead, Jerry.
I want to congratulate Professor Mo on what appears to be an outstanding study, and congratulate the U.S. Asia Law Institute for making this available. I'm very excited about this program. It vindicates over half a century of research that many of us have done on the criminal justice system. And I look forward to reading the book and perhaps even someday seeing the movie. I certainly agree with Professor Mo that this book will not be published in China, but it will have profound reverberations in China through the academic and scholarly people, but also through officialdom. One point we shouldn't overlook is the human contacts. Chinese prosecutors, even police, in my years of interviewing them, have demonstrated a felt need to talk to other people, especially professionals, about their accomplishments and their problems. Many of them, having studied law, have a sense of guilt about failures to stand up to what they learned at law school and what they know about other systems. They want to talk about it and they want to learn, and I can well appreciate how Grace Mo managed to befriend some of them and learn the realities of justice. I could go on about that because this has been my life work, but I wanted to ask Professor Mo to say a little bit more. The courts, I know, sometimes have, in examining the case prior to trial, found defects in what the prosecution presents. And as she says, they sometimes then communicate to the prosecution what these defects are. Sometimes, in my experience, the case has died then. Sometimes the police and the prosecution have used as an excuse the so-called Chubao Hoshan. They just say the witnesses or the accused is being released subject to trial, and the case is quietly dropped. But often, as the law provides, the court sends the case back to the prosecution. And there are limits on this. And I wonder if she'd say a little more about the circumstances she knows in which the courts will send the case back to the prosecution and hope that it will then be resubmitted to the court. This is all an effort to avoid, as she indicates, the embarrassment and the career limits that it will impose upon a prosecutor whose case is unsuccessful. What happens to these cases ultimately? The more she can say about that, I think the more we will appreciate the fruits of her research.
Thank you, Professor Cohen. Yeah, I read your work. It's a very inspirational, and yeah, I has been very we know that your research is very important to Chinese criminal justice as well. And thank you very much for your comments on my work. So just revert to what you have asked. Indeed, the court sometimes would communicate with the prosecutor if they identify the problem, and then quietly ask the prosecutor to withdraw those cases, to basically to recook those cases, like to reinvestigate, or until the case to say whether this cases can be dismissed or whether this cases needs more evidence. So the procedure is like this. If a case has been trialed, so for example, if the court has not identified the problem and the case has already been tried, then it is impossible to withdraw the case from the court or to add more evidence. Sometimes it can be allowed, but as far as I concerned, I haven't seen many instances. So the evidence may not be accepted by the court after that stage. So if the court has not identified the problem prior to the trial, then the case is not allowed to be withdrawn. Then if the case is really, really weak, the court have to acquit it. But as you said, that is going to be very, very embarrassing. So if the court has identified the problem prior to the trial, then what they can do is that they will inform the prosecutor to relook at the case. If the court can persuade the prosecution that there is a problem, then the prosecution would quietly withdraw the case. And then if the case is really weak, they can dismiss the case. Whether the case will be in the future will be reinvestigated or not, it depends on the prosecutor's opinion and also the court's opinion. Sometimes the court would, the police opinion. The police would be very, very stubborn, and they believe the case is very strong. They would repeatedly file the new case, but it's exactly in the old case that then put forward to the prosecution. So depends on the specific case. So how the court can do that, can withdraw the case from the court? Usually it's about secretly swap the case files. So for example, the case that has already been accepted by the court, they would have a register, and then they would register the case number, etc. But then if the case is not strong enough, then they would substitute that case with a different case. So the court would be, so this case would be secretly transferred back to the prosecution. Then the prosecution, it's up to the prosecution to decide whether the case should be dismissed or needs further investigation, adding more evidence, something like that. I don't know whether that has answered your question or.
Who is more powerful, the public security, the police, or the prosecutor? In some countries, the prosecutor is king. In some countries, the police, the secret police, and the party really dominate. What's the hierarchy that you've observed?
That is actually quite a good question. So lots of people, for example, say the police is more powerful than the prosecution. And this is true to some extent because police have lots of coercive power. They can do things to the individual, and they gather evidence, and the facts is determined by the investigation. So the police is definitely one of the very key figures. But based on my observation, the prosecution is also very powerful. So police would have to listen to the prosecution's instruction. And if the prosecution refused to prosecute the case, then the police would sometimes be in trouble. So there is a kind of a power dilemma between the police and the prosecutor. And sometimes it's difficult to tell which one is actually stronger than or not, because it depends on the specific circumstances. So for example, the prosecutor thinks the evidence is weak, they would outline what needs to do for the police to reinvestigate the case. They would give a detailed outline, and the police needs to follow the instruction and gather more evidence, etc. And if the evidence is not strong, then the prosecutor can threaten them to discontinue the case. So they do have some bargain chips on the police, and in most instances they can check the police power, but there are also situations that the prosecutor cannot really control the police. So for example, if there are situations, if the police already decided to prosecute the case, but they think that some of the evidence needs to be strengthened, then they ask the police to cooperate. But the police knowing that their task has been finished, they just dismiss the prosecutor, and then the prosecutor can no longer control them. So it depends on the specific situation, and it is difficult to tell which one is stronger than the other.
What about the party political legal committee?
In the past, indeed, the party political committee was very influential. They could intervene in individual cases and give specific instruction to the prosecutor and the police. So, for example, during my field work, I remember that there was a case. It is actually a private nuisance case, which I think is about neighbor dispute. But one of the neighbor was kind of minorly injured, so the police filed the case as an assault. Then the case sent to the prosecution, and the prosecution thinks this case is really, really minor and not really amounts to crime. So he strongly suggests that the police to dismiss the case. But the political legal committee intervened in this case because the victim, apparently there is some individual, private they have some kind of issue with their neighbor, so they really want to put the case to a high profile. So the political legal committee was kind of being influenced by the victim of this case, and constantly put pressure on the prosecutor to to prosecute the case. And the prosecutor, they have to persuade the political legal committee not to follow his instruction. So there has been a long battle in that regard, and that case lasted about 3 years, and the committee still put pressure, and I think eventually that case has been dropped, but still it put lots of pressure on the prosecutor, and all the leaders of prosecutor has been involved, and they have prepared over hundreds of pages to explain why the case and evidence is not strong, that kind of thing. So it is definitely a key player. But I think until 2015 or 2016, I can't remember the year, but the party committee has no longer be allowed to intervene in individual cases because of their previous involvement has resulted in miscarriage of justice. So I think their influence has been diminished over the years. But having said that, there are probably still some kind of sensitive cases. You could still detect their their presence, which put lots of pressure on these legal actors.
So thanks, Grace. I want to go to a series of questions that people have asked about witnesses. And I'll sum up some of the questions, and then maybe we could turn to Professor Don Clark and turn on his mic. One of the questions was whether prosecutors have an obligation to personally interview all the witnesses whose statements are in the police dossier, or do they just accept the written statements as presented by the police?
Okay, thanks. The prosecutors can interview any witnesses they want, but most of them they wouldn't, because it's very time consuming. And for the procuratorate that I worked within, they only compulsorily allowed to, they're only compulsorily supposed to interview a small selection of cases in which the witnesses are their testimony are regarded as crucial. So, for example, like sexual offenses, and also sexual assault, I think, and also rape case. I think corruption related cases that I can't remember, but if I recall correctly, for the prosecutor that I worked with, they were only allowed to verify this small categories of witnesses. For the vast majority of witnesses, they only just check their statements.
Great. Don, you had a question about witnesses or a comment, I think.
Yeah, thanks very much. So again, great book, Grace. This is just fabulous work you've done. So on the question of why witnesses don't come to court, I would have thought the answer was clear. And so I'd like to hear your comments. And the answer being is that the side that uses the witness testimony doesn't suffer any penalty if the witness does not come to court. So even if they don't bring the witness, the statement is still going to be accepted into evidence. So, if I'm a prosecutor, why would I ever want to bring a witness to court? I mean, there's no upside, there's only downside. And therefore, it seems to me completely unsurprising that we don't see witnesses. And so to me, it seems to me it's not the absence of witnesses that needs to be explained. What would need to be explained is why we would ever see witnesses. So I think that, if Chinese criminal procedure were to have a rule that when a witness doesn't show up, you don't accept their evidence. If they had that rule, we would see witnesses, but there isn't any such rule. I did have another one, but I know there's loads of people waiting, so I'll skip my second question. Thanks.
Yeah, I agree with you, Don. Exactly. So the reason why witnesses do not appear was because of the prosecution and dossier is sufficient. So the person who wants witnesses to appear is defense lawyer. So that's why it is about challenging the prosecution case. What if witnesses can appear? They are given a chance to challenge the prosecution case so that they can change the facts and maybe leads to different outcome. But the problem is for number of years this hasn't happened, and now even if the witnesses do appear and being cross-examined, still if that has been contradictory to the prosecution evidence, the court still accept the written evidence rather than the oral live testimony.
So I had a follow-up question. There's an old saying about the process of a criminal case, that the police cook the meal, the prosecutors serve the meal, and the judges eat the meal. So the whole idea that the police create the dossier, which then becomes the subject matter of the case, and that gets passed to the prosecutor and then the judge, sort of captured by that statement. And clearly the party and the leaders are aware of this. And so when Xi Jinping came to power and Zhou Qiang was appointed the president of the Supreme People's Court, they came up with two slogans. One was that the people should feel justice and fairness in every case. And the other was that the trial should be the center of a criminal case. Just 以审判为中心. And as part of that, there have been several reforms. You mentioned some of them. The exclusionary rule for coerced confessions. It's been written into the criminal procedure law that judges have the power to order witnesses, important witnesses, to actually come to court and testify. As part of the trial-centered justice, I think now forensic examiners are generally required to testify in person. And also, I'd say the last one is that police interrogations of suspects in serious cases are all supposed to be videotaped and audio taped, and from the beginning to the end. But in your research, how have these reforms actually played out in practice? Have they contributed to an improvement in the process? Have they enhanced the due process of a criminal trial? How have they actually played out?
Yes, so I did my field work relatively early in 2012 and 2013. At that point, none of those measures was in place. So for example, I only saw one witness came to the court, and and that was like a showcase to show that the court can actually handle a witness, because there are other brother courts who came to visit this court to learn how the court could preside the procedure so that the witness can be cross-examined. So that was quite early on. And from that example, you could say almost, no witness actually appeared in China. And this, in recent years, indeed, there has been new measures put in place to encourage witnesses to come to the court. So the problem of the court, from the court's perspective, it's not about not allowing witnesses to come to the court, because it's not, they are not concerned about that. The concern is what's happened if the witness gave a testimony which contradicts the prosecution case. So, for example, like things like the forensic evidence and other kinds of evidence, if that's consistent with the prosecution case, there's no problem. And sometimes it's just this kind of reform could reinforce the legitimacy that the procedure is fair and not as bad as people think. And there are lots of elements of due process. But the real test of those kind of cases is whether when the witness actually retract their earlier statement and put a different testimony, which is very damaging to the prosecution. So how the court is going to handle those cases is going to be a challenge for them, whether they are going to, which version are they going to adopt? Are they going to use the oral testimony, or are they going to use the written dossier? So as far as I know, there are some of the defense lawyers already complain that now the court allow witnesses to be cross-examined, but the court still use a case dossier. And what is the point? So how that's going to be put in practice, I don't know. And whether this is just a show, because they still follow the old practice, and the court center is just how do you say that?
Empty slogan.
Empty slogan, or adding guilt to Lily, that kind of thing. It's a really it still needs to be investigated, it needs to be explored. So
great. And there were some questions about the recording of interrogations. Are the recordings made part of the dossier? Are they available to the court? You also mentioned in your research that maybe it seems like sometimes the recordings do get edited. There's even though the law says that it should be a 全程录音录像, it should be recorded from beginning to end. That doesn't always happen in practice.
So in practice, in earlier years, for example, up to until I have finished my draft of my book, the video recording of the interrogation is constantly being edited, and all this kind of a video recording is rehearsed. So they already got the statement, and then they ask the defendant, the suspect, to cooperate with the police and read out the transcripts they prepared for them. So that is a kind of staged show. So that's actually happened before. And lots of defense lawyers complained about it. And then there was a new judicial directive has issued by the Minister of Public Security, which require all the video recordings to be kept intact and not allowed to be tampered. After that, then I think there has been some change in practice, so that they cannot obviously editing the recording. But the problem of the recording is that it's like in a CD disk attached to the case file. They usually do not give that CD file, the CD to the defense lawyer until the trial. So they can only watch it at court. They cannot watch outside the court. And also usually that kind of a video recording is quite long and the facility is limited. And there is no written document to really show what this video is about. So that kind of video recording is actually nobody really wanted to watch because of all kinds of constraints being put in place. So whether that video recording is being treated as a crucial evidence or not, I don't think any of the defense lawyer would wanted to sit in a court for half a day just to watch. And if there's a problem, it's difficult to protest that kind of problem as well. So it is that kind of evidence is basically being ignored in practice. It's no longer being significant.
So we're coming to almost the end of our hour and a half, and there are quite a few questions I haven't gotten to yet, and I apologize. But I wanted to let everyone know that the introduction to your book is available on our website. Anybody who is registered for this talk can go to the website and download it, and I highly recommend it. I think in your introduction, you lay out very clearly the theory of constructing the criminal case in China and the theory of the truth. I wanted to add a comment in terms of comparing the Chinese system with other systems where the police case gets tested in court through cross-examination and live witness testimony. The fact that that there's a possibility that the police investigation will be tested down the road really changes the behavior of investigators. If you know that you may have to testify one day about how you interviewed a witness or how you interrogated a suspect, it changes the way you go about interrogating them or questioning them and writing a report about it. You don't want to be discovered that you massaged the testimony of a witness, or you changed what somebody said, or you only included the inculpatory statements and didn't include any of the exculpatory statements. So it's not even just that the prosecution case would be tested in court, just the fact that there's a possibility it would be tested in court changes the behavior of investigators. The last question, I just want to summarize, I think it was a question from Josh Rosenzweig, mentions, and it's come up before, wrongful convictions have been publicized more and more in the Chinese system in the last few years. And we at the US Asian Law Institute have done a whole 5 years worth of programs about causes of wrongful convictions and how to prevent them. And I wonder, based on your research, if you see wrongful convictions in China as an aberration, where the system has, something out of the ordinary happens to produce a wrongful conviction, or is it a more natural consequence of the way guilt is constructed in China?
Yeah, so my book basically said it's inevitable outcome because of the way evidence is constructed. It is not just about serious cases like cases involved in murder or death penalties. Those cases can be, attract media attention, so everybody knows there's a wrongful conviction. There are lots of low-level crimes, the crimes which may not be interest to the general public or not be able to attract any media attention. but those crimes, the wrongful conviction, which can still affect a person's life, significantly. So that kind of a wrongful conviction happens, I think, on a daily basis. It depends on how the evidence is constructed and how the person is treated in the criminal justice system for the lack of safeguards. Yeah.
So thank you so much. This has been a fantastic program. I think for myself, I could go on for, a few more hours. And I think we'll have to find a way to continue this conversation. But I highly recommend the book. I think you've given people a great introduction to your research. And it's really, you really are to be commended, as many of the speakers have said, for the in-depth work that you've done and the frank way you've gone about it and explaining it. So thank you very much. And I want to thank everybody who asked a question or who just called in to listen. And again, next week, we'll have another excellent program of interest to many of you about the foreign NGO law and how it's affected how foreign NGOs operate in China. So thank you, Grace.
Thank you for having me. It's my great pleasure to give this talk and communicate with my readers.